Get started. Good morning, everyone. It's good to see you virtually. Very happy today to have Angel Yang Riley from Chauvel Glatt, who's a probate and trust attorney. And I can attest that she is very professional and efficient. I just had one done after my mother recently passed. So I know Angel's a Chamber of Commerce board member, and she's also a Rotarian for the Noontime Rotary Club. And I just think she's amazing. Don't want to build her up too much, but she's really a fantastic young woman. So with that, take it away, Angel. Oh, you will be muted. I'm sorry, I always forget this part. You will be muted. And then as we get towards the end, if you want to hit the chat box, if you have a question, then Pauline will unmute you to ask your question. And looking forward to Angel's presentation. Thank you very much.
Hi, Cheryl. Thank you so much for having me. I see people are popping in. And before I get started, I just thank everyone for spending your morning with me. I know we're going through some pretty, very frankly, challenging and difficult times. And it's just great to be able to connect with you on this level. And thank you for being here with me. So the topic that I have today for us is estate planning and why everyone in California should have one. And with that, I'm going to start my presentation with a PowerPoint. Okay. So before I get started officially with the content, I do have to give you all a disclaimer. Some of you are on your phone, so I do have to read this out loud. And the disclaimer is no information presented in this presentation constitutes legal advice, nor is it intended to be fact specific, as there may be occasions where Angel Riley or Chauvel Glatt clients who may be adverse to your interests, discussion, questions, or any program content related to this webinar cannot touch upon any fact-specific matters. Attendees should consult with knowledgeable legal counsel to determine how applicable laws pertain to specific facts and situations. Also, be further advised that these materials are based on the most current information available, since it is possible laws or other circumstances may have changed since this presentation. Please consult with legal counsel to discuss any action you may be considering as a result of attending this webinar. Attendance at this program and or receipt of these materials is not intended to create, nor does it establish an attorney-client relationship. Okay. So topics today, 3 major components, which is why do I need an estate plan? What is an estate plan? I already have a will. Is that going to be enough? And estate planning for individuals without a surviving spouse or children, and what that means if they don't have a trust. So what is an estate plan? Those of you that have one know that a comprehensive estate plan includes a living trust, a will, and powers of attorney for healthcare and property. So a living trust in California is the only document that can help you bypass probate, okay? And what is probate? We'll get to that on the next slide. In essence, a living trust is a document whereby you state where you want your assets to go at the time of your death, who is going to manage those assets for you, and how they'll be distributed, okay? A will usually covers personal property, and in the event something is left out of a living trust, the will usually in California has a pour over effect, which can tend to speed up the probate process. And then powers of attorney for healthcare and property are necessary in the event any one of us reach a point of incapacity in life. A doctor or a bank is going to need a power of attorney in order for your successor agent to act on your behalf. And one of the things that I want to touch up on regarding a living trust is in California, the threshold for probate is, as of this year, about $166,000. So what that means is if, let's say, someone passes away today with $200,000 to his or her name, right? That automatically puts them into the necessity of having to go through probate court. If you die with assets today of less than $166,000 to your name, in theory, there is no probate. However, that amount does not include mobile homes and various other assets that would still need to be probated. So common misconception is people think, oh, I only have X amount, I only have this, I only have that. Don't automatically discount a modest estate as not needing an estate plan. And with powers of attorney, we are entering a time frame where high schoolers are graduating from high school and entering into college. One of the things that we do here in the firm is we have this grad special where if you have children that just turned 18 or are maybe taking a gap year from college or are back from college, we encourage parents to think about having their children prepare and finalize a power of attorney, because the reality is when your child reaches the age of 18, guess what? They're adults in the eyes of the law, right? They can go out and create their own bank account. They can go out and obtain credit cards. They can legally marry. They can sign legal contracts. And so, God forbid something happens to that child, you as a parent want to be sure that a doctor and a bank is going to speak with you without having these legal barriers. Okay. And this last point here, fund your trust with your assets, is particularly important if you have a living trust, because if you have a document, if you just have a living trust, that document of itself is pretty much moot if there's no assets in the trust, right? So over the years of practice, I have reviewed quite a few trusts where there are no assets in the trust, meaning the attorney who drafted the trust never fully transferred the client's assets into the trust, which is malpractice. And quite frankly, it's very troublesome, because if the assets are not in the trust, then all those assets at the death of the client is subject to probate. Okay, and with that, let's move on into the next slide. Okay, why do you need an estate plan? So the main reason is you want to protect your assets against probate. Okay, what is probate? So probate is a court proceeding for beneficiaries of a will or heirs of an estate to inherit assets from a decedent. Okay. The cost of probate is expensive. For example, if I probate an estate that's worth, let's say, about $1 million, which in the Bay Area is fairly common, the attorney's fees off the bat is about approximately $20,000. And the attorney's fees is based on a statutory formula that is stated in the California Probate Code. So when you take that into consideration, you think, preparing an estate plan maybe at the outset is going to cost, let's say, between $3,000 to $5,000, depending on the individual's assets and marital status. But on the back end, if your assets are worth $1 million, then the attorney's fees amounts to almost $20,000. So, just the base on the cost, it makes great sense to have an estate plan, or at least think about it and talk about it with an attorney. And lastly, the time, right? The time for probate in California, even in its most friendly situation, meaning the family members all get along and there's no contention, it's about a year. Of course, if there is fighting or contention involved, it can be much, much longer. And that's one of the things that, that I witness that's particularly difficult as a planner is, when someone dies and there aren't proper estate plans, then really the family members of the deceased are kind of stripped of even the opportunity to grieve the decedent's death, because now they have to deal with this lengthy court system that they really don't know how to navigate. And for many, it is incredibly stressful. And really, you know, from what I witnessed, it takes away from the memory of the decedent, which if you ask a client, that's the last thing they'd want to leave to their family members when they die. Okay, and of course, why do you need an estate plan? You need an estate plan so you can ensure that your assets are distributed based on your specific wishes. Okay, and next slide is, I already have a will. Won't that avoid probate? The answer is no. That is a very common misconception. People often say or think, you know, if I wrote down a will on a piece of paper, it's stored in my safety deposit box, or years ago, attorney drafted a 5-6 page will for me, I'm good, I'm covered under the probate code. The answer is no. Wills are still probated. The will, at best, just gives the probate judge an idea of where you want your assets to go. So he doesn't default to the probate code to distribute your assets. However, you are not bypassing that attorney's fees that we just talked about to probate a will, and you are definitely not bypassing the time frame it takes in order to probate a will. Okay, and that's something that's really important for, I think, clients to discuss with an attorney, because sometimes a will is enough if you know, let's say only have, you know, $20,000 to your name, because that's below the threshold for probate we discussed earlier. But most people in certainly the Bay Area is not in that category. So before you jump to this conclusion, please speak to an attorney. All right, and then the next slide, I put this up here just so we all have an idea of how complicated a probate can be if the individual dies with no will. So I've probated quite a few estates where the person died having no surviving spouse or children, and the story behind them having no estate plan per their surviving distant cousin or whatnot is that this person thought, you know, who cares? I don't have a spouse, I don't have a children, why do I need an estate plan? So I want all of us, if you can see this, take a look at the slide and just read this to yourself. And for those of us that are on the phone, I'm going to read it loud to you. So California Probate Code Section 240 states, the property shall be divided into as many equal shares as there are living members of the nearest generation of issue then living, and deceased members of that generation who leave issue then living. Each living member of the nearest generation of issue then living receiving one share, and the share of each deceased member of that generation who leaves issue then living being divided in the same manner among his or her then living issue. So if you're confused about what you just read or what you just heard from me, you're not alone. I think it takes even practitioners quite a while to truly unravel what Probate Code Section 240 means. And Probate Code Section 240 is basically the default rule of how to distribute one's assets if that person dies with no will. Okay. And on the next slide, if you can see it, is essentially a table of how probate is administered if the individual does die with no will. And as you can see in the left side of the graph, you start off with the person, which is the deceased person, right? And if that person has children, it's fairly easy, it goes down to the children. That person has deceased children, it goes down to the grandchildren, and so forth. If that person has no children, no grandchildren, no great-grandchildren, but surviving parents, then the surviving parents are going to be the individuals to inherit the estate. And if that person has no surviving parents, then it goes to their brothers and sisters, then their nieces and nephews, and so forth. What gets complicated is people that die thinking, I don't have any children, I don't have My parents are deceased. I have no surviving spouse. I'm the only child. I have no siblings, and I certainly have no nieces and nephews. Well, about 2 years ago, I probated an estate, and it was that same story of a female who died in Alameda County, and she had no parents, no surviving parents, no siblings, no nieces and nephews, no children. She only had one cousin that she knew about, and the cousin also only knew her as the surviving relative on that side of the family. Turns out we ended up getting about 22 or around that number of heirs pop out in the probate proceeding. And they were all legitimate heirs because they all provided me proof that some 80 years ago, some great grandparent came from Germany, brought over or had 10 kids here in the States. And of course, those 10 kids had their children, and those children had their children. And so what gets complicated in a probate is you may think that you don't have any relatives that you ever knew, but the probate code doesn't really care about who you knew or who you were close with. So long as that individual claiming to be an heir is a blood relative, even if they're second cousin once removed, second cousin twice removed, that individual is subject to receiving a piece of the pie. So this and the stories that I have regarding probates like that should be enough of a reason for anyone, even if they don't have any children or surviving spouse, or maybe close relatives to them that they've ever known, to have an estate plan. All right, and so just a summary of what we just discussed, and I imagine that we'll have some questions, is a living trust shelters your assets and avoids probate, but a will is not enough to bypass probate. You need a living trust, and that is the only document in California to avoid the probate process. The probate process is expensive and can be lengthy, and everyone needs some form of an estate plan, even if that individual dies without a surviving spouse or child. And as I discussed earlier, even if you are just 18 and you have no assets, or maybe you're 21 and you have more loans than assets, right? You still need powers of attorney for healthcare and property. And the last part here is, if you have an estate plan, or even if you don't, please keep yourself updated with the changes in tax law, which at a minimum, I tell clients, take out your trust every 4 years, because in theory, our presidents change every 4 years. Or if you forget, then at least every 8 years, you need to take out your estate plan and review it, because with every presidency, usually the tax laws change. And the last slide here is again a disclaimer, which I read earlier. Okay, and then lastly, this last slide is my contact information. Those of you on the phone, if you're interested in reaching out to me, my phone number is 650-573-9500. And if you need to email me or prefer that avenue, it's angel@Chauvel Law, CHAUVELLAW.com. Okay, and that's the presentation. Thank you so much for your attention.
Thank you, Angel. Does anybody have a question for Angel? So please put it in the chat box, which is located down on the bottom of your screen. Ash, do you have a question? Okay, well, if not, I will just end this by saying that thank you very much for participating in the San Mateo Area Chamber of Commerce Business Essentials series. And it is sponsored by the Chamber and free of charge for anybody. We are doing 3 a week. Tomorrow we are going to have someone from Backblaze talking about how to remotely back up your hard drive so that you can stay safe. And we have a very exciting event this Saturday where we are uh, participating with 4 of our chamber members, Crystal Springs Catering, the Marriott, uh, Dove Chocolates, and also Bella Fiore Flowers. And you just need to go on the San Mateo Chamber website, click the link, and you can order a meal, your wine, flowers, and chocolate for Mother's Day this Sunday. The pickup will be from 1 to 3 on Saturday, and we will be there helping to distribute the food. So if you don't have any plans for Mother's Day, then please join in. We would love it.
Yeah, we have some questions now, Cheryl.
Yes.
Oh, okay, good. I just had to talk for a while. Okay, great.
Okay. Question from Gary. Where does a pour over will come in?
So a pour over will comes in the event if the individual dies and at that time of death, either assets were left out of the trust or were inadvertently taken out and never put back in. So a perfect example is I personally just went through this, and I've probated many estates where a pour over will does come in despite the individual having a living trust. So I recently refinanced my home, and those of you that have a living trust, you know that for some reason still the banks make you take it out of the trust, put it in your name. They finished a refinance, and sometimes they don't remind you to put it back into the trust, which technically they don't have to, right? They're not your attorneys. They don't owe you that responsibility. Fast forward 30 years, somebody dies, and the family comes to me. I look up the deed and I realize, oh my God, 30 years ago, your mom or dad transferred the property out of the trust for this refinance, and they never put it back in. Well, guess what? If you have property that's not in trust, it's subject to probate, and it is going to probate. And so when that happens, you have that's when the pour over will comes in, whereby the judge takes a look at the will, and he says, okay, this person has a pour over effect in his will, stating that if I ever leave anything out of my trust, I would like the judge to transfer it back into my trust, pouring it over for administration by the trustee. Okay. However, that's still costly. You're still in probate court. So the ultimate lesson here across the board is make sure you have a living trust and make sure that all your assets that need to be funded into the trust are placed into the trust.
Right. And another question, should we also set up secondary powers of attorney? For example, if you and your spouse were to both be in an accident and die.
Yes. So so they're not called secondary powers of attorney, right? They're powers of attorney. What you would do is you would first nominate a primary agent, let's say a spouse, or if you have no spouse, maybe a sibling or a parent, and then you would appoint a backup, right? Just in case that your primary agent is not there or available to make those medical or financial decisions for you. So yes, it is very important to have backups.
Okay, and I think this is related to the pour over. What about bank accounts outside the trust?
So for this one, it's a little bit, okay, and I see the person asks, are they subject to probate after a certain amount? Yeah. Yes, so the threshold for probate in California is about right now $166,000, right? So let's say you have a checking account or a money market or a stock account that's over that threshold. Absolutely, that account needs to be probated, okay? Which is kind of tragic because the account's, less than $200,000 and you still have to go through a year's process in order for the family members to inherit the account. Now, with respect to whether or not you need to transfer all accounts into the trust, typically what I tell my clients is, if you have a checking account that goes from, let's say, 10 grand at the beginning of the month down to, I don't know, $1,000, right? Because of bills. That one you can probably keep out of the trust because it's below the threshold. And also these banks, when you convert a regular account to a trust account, they sometimes make you change the account number, which for most of us that have auto pay, that's kind of annoying. And so for my clients who don't want to go through that, I tell them, if it's that particular account where again, it's, 10,000 in the beginning, it drops down to about $1,000 or somewhere around, low, a low amount at the end of the month, you can probably leave it out. But if you have an account that's just sitting there generating interest and income, you really want to make sure it's in the trust because chances are, we all forget about some account that we have. I know that I have. And, you just don't know how much interest can accumulate over the decades. And you don't want that sole account to be the reason why your family need to go to probate for you.
Great. Are there any other questions?
You're welcome, Karen.
Oh, there's another one. Does the answer on the bank accounts apply to each account individually or all cumulatively?
So if you have, I think this question is with respect to accounts where you have like one account number and then underneath that account number, you have like sub accounts. In my experience, if you put that, I guess, parent account into the trust, you're okay. But to be safe, it doesn't take much for the individual to just ask their banker or clearly tell the banker, look, I need to put these accounts into the trust. How do I do that? And never assume, make sure once you do that you get some kind of statement or a printout of your new account information, or carefully look at what the next account statements states in terms of the title of the account to ensure that you did what you do.
Yeah, Michael clarified, he said the question relates to the total amount of money in all accounts.
So again, the threshold for probate is $166,000. And so you really, let's say you have, I don't know, $50,000 at Chase and then $50,000 at Wells Fargo and $50,000 or, $80,000 at US Bank, okay? You don't want to gamble and leave them out because in your mind you think perhaps, oh, separately they don't add up to $160,000. But the rule of probate is all your assets, right? So if that's what Michael you mean, then I would, in that example, advise the client to make sure that all those accounts are in the trust.
Okay, well, that was wonderful, Angel. You did a great job. I hope some of you got some answers to your most burning trust questions. And with that, enjoy this wonderful weather. I don't know about you, but I'm getting tired of saying stay safe and healthy, but stay safe and healthy. And we will see you soon. Thank you so much.
Thank you everyone for joining me, and thank you Cheryl and Pauline for setting this up. It's been fun, and if you have other questions, feel free to give me a call or shoot me an email.
Yeah, we're going to capture this recording and we'll post it on our YouTube channel. Thank you, everyone.
Thank
you,
you.
Cheryl. Thank you, Pauline.
Bye.
Thanks,
Bye-bye.
everyone.
Bye.
Bye-bye.